Welcome to this video on how to draft effective intellectual property or IP clauses. I'm Shaitali Bhugade and I'll be guiding you through this process. Our agenda is to learn why IP clauses are important, what intellectual property is, how to define it, and how to decide ownership.
Why is an IP clause important? Because clear drafting today prevents disputes tomorrow. A well-drafted clause prevents ownership disputes, protects creative work, defines usage rights clearly, and avoids future litigation, which is essential in commercial contracts. Intellectual property includes copyrights, trademarks, patents, designs, and trade secrets. In India, these are governed under the Copyright Act 1957, the Trademarks Act 1999, and the Patents Act 1970. IP clauses are used in various agreements, such as consultancy agreements, employment contracts, SaaS agreements, brand sponsorship agreements, and software development contracts. Remember to read, think, and learn from these examples. Always start by defining intellectual property clearly. For example, it includes all copyrights, trademarks, patents, trade secrets, source code, databases, and proprietary rights developed under the agreement. Be sure to avoid vague language and define the scope clearly. When deciding ownership, ask, who owns the created work? Is it work for hire? Is ownership transferred or licensed? There are RE3 models. Client owns everything, creator owns but licenses, or joint ownership. Ownership must be crystal clear. If ownership is transferred, use strong words in your assignment clause like assign, transfer, or irrevocably assigns. Without assignment wording, ownership may not legally transfer. An example is, the consultant hereby irrevocably assigns all rights, title, and interest in the deliverables to the company. Moral rights are important in India. Under the Copyright Act 1957, authors have moral rights. Include a clause if required, such as, quote, the consultant waives all moral rights to the extent permitted under law. This is especially important in creative work.
The license clause, if you are not assigning ownership. Specify if the license is exclusive or non-exclusive, the territory, duration, and sub-licensing rights. For example, the consultant grants a non-exclusive, royalty-free, worldwide license to use the deliverables. Clarity prevents disputes.
It is very important for freelancers to protect their pre-existing intellectual property. Include a clause stating, any pre-existing intellectual property of the consultant shall remain the sole property of the consultant. Otherwise, the client may claim everything created. If the deliverables include sensitive information like source code, a business formula, or internal data, then add confidentiality protection. IP and confidentiality clauses should always work together to ensure full protection of trade secrets. This is an example of an intellectual property rights clause in a consultancy agreement, following the ownership transfer model, starting with definitions of intellectual property rights and deliverables. It's important to clearly define what is covered.
Continuing the example, subclause 2 states that all deliverables shall be the sole property of the company and, to the extent permissible, constitute work made for hire. Subclause 3 details the assignment of IP, making it worldwide, perpetual, royalty-free, transferable, and sub-licensable.
The sample continues with moral rights, where the consultant waives these rights to the extent permitted. Section 5 details exclusions, clearly stating that background IP, general skills, and third-party materials remain with the consultant, granting only a limited license for background IP use. Section 6 addresses third-party infringement and indemnity, where the consultant warrants that the deliverables do not infringe on any third-party IP rights and agrees to indemnify the company against any such claims. Section 7, survival, ensures this clause survives termination of the agreement. Next, we examine the intellectual property clause within a franchise agreement using a license and brand protection model, where ownership is retained by the franchisor. Clause 1 establishes ownership of all trademarks, logos, and proprietary materials as the sole property of the franchisor.
Subclause 2 details the grant of license. The franchisor grants the franchisee a limited, non-exclusive, non-transferable, non-sublicensable, and revocable license to use the IP only for the operation of the franchised outlet. The license is restricted to the territory and brand guidelines, and it automatically terminates upon agreement termination. Subclause 3 outlines various restrictions. The franchisee shall not modify or alter the trademarks, register confusingly similar marks, use the IP outside the defined territory, use the IP for unauthorized purposes, or challenge the ownership of the franchisor's IP. Subclause 4 lists exclusions from license, explicitly excluding any right to ownership, sublicense, assign, or create derivative works. Subclause 5 on goodwill states that all goodwill generated from the use of the trademarks accrues solely to the benefit of the franchisor. Subclause 6 mandates that the franchisee promptly notify the franchisor of any IP infringement. The franchisor retains the sole right to initiate legal proceedings. Subclause 7 covers post-termination obligations, requiring the franchisee to cease all IP use, remove branding, return documents, and not claim any continuing association. Finally, Subclause 8 on confidentiality of system ensures that the franchisee acknowledges that the operational system, data, and strategies are trade secrets and must not be disclosed during or after the term of the agreement. Thank you for watching this video. I hope this guide on drafting intellectual property clauses has been helpful. Like, share, subscribe.